I think there's a way that we can break it down that everybody can understand what happened.
Surely.
But the long story short is what we achieved with respect to some of the comments that were made at the CCJ, in my opinion, are more than I could have hoped for. I probably hoped for more, actually. We wanted everything, but what they gave us towards the end of the judgment, some in bits in between, and then by the time we got to the very end, you could really see that they clearly expressed the view. There was clear dissatisfaction, in my opinion, in reading the judgment. And I think by any lay person reading the judgment, that there was dissatisfaction with how our elections were conducted in 2019. And what we really wanted more than anything, especially at that stage of the litigation where the elections had passed 2.5 years, whatever, at the end, the goal really was for people to take the allegations seriously, and we weren't just making things up, without evidence. It wasn't a question of disgruntled party that lost an election and couldn't accept it. There were real problems with the election, and we needed the apex court to recognize that. And when I decided to come on the matter, I always had in my head from the very beginning that I wanted to end up at the CCJ. That was always my goal, because I have a lot of respect for the court. They have a strong emphasis on doing what's right by the Caribbean people. It's in their preamble, it's in the agreement that establishes the CCJ and so on. It's very clear that that's the focus of that court. And what's interesting is that there was a case coming out of, I don't remember exactly right now, but it's another Caribbean case, Eastern Caribbean Court. And they wanted to appeal a cost order from the either the High Court, at the High Court, in a petition matter similar to ours. What we filed is an election petition. So it was another election petition matter, and the costs were really high that was awarded against the petitioners who lost, right? And they appealed all the way to the CCJ. To say, look, can you at least help us out on these costs? We understand that we've lost, but the costs are exorbitant, and they were. And the Privy Council said that they did not have the jurisdiction to even entertain hearing them, because based on our constitution, which is basically was also what's set out in this judgment, when it comes to election petition matters, they end at the Court of Appeal, right? So there were no further rights of audience for them at the apex court, which at the time was the Privy Council. So the Privy Council will not even let them through the door to even consider giving them leave to be heard on the matter. And so we were in a similar position where we're dealing with election petition. We've gone through the High Court, gone through the Court of Appeal, can't go any further. And we're now back like these petitioners were in that other case, where we're saying to the CCJ, can you just hear us? We want leave for you to hear us. And the respondents, or the other side, they filed an application to say we don't even get to be heard or considered at all. And they wanted us to be struck out at the door, which is essentially what happened to us at the Court of Appeal. Well, actually, no, at least at the Court of Appeal, we got to argue whether or not we should be heard. They didn't want us to be heard at all. And at that point, we'd already filed our documents asking for leave and saying why we wanted leave. And what's different between that court and what happened at the Privy Council is that they said, we will hear you, right? And that in itself was already a victory for us. And I knew that the fact that they were willing to hear us meant that they were willing to help us. And they did. I think they did, right? So
the initial case brought before the court, just for people who probably don't understand what it is we're talking about, what was the initial filings like?
I was just about to get there. Yeah, okay. I was just about to get there when I started with that preamble.
Yeah.
Okay, so what happened is that we had the elections, right? And leading up to the election, so the way it works is your election period, when you question whether elections are fair or not, your elections period, the span of that time where you have to consider what's fair and what's unfair, begins from when the election ends to when it comes around again. So between those 5 years, you get to you can monitor and assess how your elections commissions, how your executives and so on are conducting are moving towards conducting the elections, right? So you have to compile certain lists, you have to clean the voters list, you have to make sure the right people are on the list, right? Because you can register at any time until, of course, you can't, because there's a deadline after the election is called for you to finally register to vote. But after the election is done, you can start registering again, right? And so there's always the job of these elections officers to make sure that when people come to register, they're properly qualified to do so. If somebody's passed away, you take them off the list. And then there's always the option for the public, anybody, to come in and look at the list and say, hey, this person doesn't belong on the list. And then at the end, you're supposed to use something called a revised list and a supplementary list. And the law is very, very detailed and very intricate as to how those lists are compiled. The revised list is the voters list that you use on election day together with the supplementary list. That's by law, okay? You cannot use any other list. The Court of Appeal, our Court of Appeal, and the CCJ themselves have accepted that if you do not use that revised list, your elections are null and void, period. There's no elections. The entire elections are a sham. We did not use a revised list at the Dominican elections. And the CCJ talks about that in detail and how important that is. If you do not use the revised list, your elections is a sham, period. Okay. We pleaded when we brought our petition, and I'm saying our because I acted as an attorney on behalf of the people who lost the election, called the petitioners, right? When we brought the petition, we said, look, these elections are not fair because the revised list wasn't used. There is a very important case that the CCJ referred to. It was decided by our Court of Appeal in a case called Parry versus Brantley, where they ruled very clearly, if you do not use the revised list, you have had no election. Boom, do it over, done. Simple, right? Yeah. So we're thinking, that's clear. That's clear. The defense was, yeah, we didn't use it, and so what? In layman's terms, there was no revised list, and what's your problem? Right? So they basically were saying, well, you have to show that how it affected the election results. We don't need to. The law is clear. But if you want us to, we have to go to trial to do so. Okay, so that was one thing we said. So there are a host of other things that we pleaded that went wrong during the elections. That was just one of several things, right? The other issue was that we did not have, by we, I mean the petitioners who campaigned, the opposition party did not have access to the state radio. The law is very clear from that same Parry-Brantley case. It's throughout the Commonwealth jurisdiction. We understand absolutely if you don't have equal access to the state radio, your elections are a sham. And why that is important is because there's a constitutional right for political parties to campaign on equal terms. We all, those of us who live in a country, pay taxes towards the state radio. You are entitled to have equal access to the state radio. What these petitions did, what we did was file a petition when we were complaining about the elections. The petition said, look, here are dates and dates and dates and dates that we've begged and asked DBS to carry programs of the United Workers' Party or the opposition party, right? And they didn't carry it. And for every time they asked to carry, they asked DBS to carry a function, whether it's a meeting or whatever they wanted publicized. For the 5 years, not just the 2 days before the election, for the entire 5 years between the last election and the 2019 election, they didn't carry anything. That's what the pleadings were saying. That's what my clients said. And that's squarely before the court. The people who were, it's clear that the petitioners were prepared for the petition because they documented every instance that they wrote to DBS. They had the dates, and I had the physical letters in my hand. And they said, these are the dates. This is when we asked. This is what we asked for. And every time we asked, they carried the government instead. So only the government was promoted during the elections. That is a breach of constitutional rights. They could not campaign on equal terms. Only one party was being heard. Okay? So unless you seek out some other forum, you would not hear what the UWP had to offer Dominicans, right? And my understanding is that the United Workers' Party did not just experience that with the state radio, but with other places. So they effectively were just cut out from the campaigning system for 5 years, right? Not just those 2 years or whatever, 2 days before the elections. So there was that. That's a big one. The other one was there was a treating. Well, people are very familiar with the whole treating stuff. What was interesting about the treating bit is that there was a specific allegation. I think the number we used was either thousands and thousands, or maybe I think even tens of thousands. A huge number we pleaded of people were paid for to come in to vote. We know this happens in Dominica, right? That is squarely against the law. Even if for some people you think, oh, what's the big deal? It matters, especially if one party has, and which we've also pleaded, way more access to funds than the other one. It's not fair, right? And what they said in their responses, not that they didn't do it, right? They said, yeah, we did it. So what? We brought in our supporters, right? They've just blatantly, clearly said, we did it, big deal. The people we brought in were our supporters. So if I'm not supporting Labour and I want to fly into Dominica to vote, no, you can't, right? So that is bribery, treating, whatever. That's illegal. You don't do that. And they put it in black and white. We did it. So what? And that's what was before the High Court judge, right? So basically, we had a bunch of really serious allegations like these that are clearly recognized in law as being acts that would lead to your elections being a sham or illegal or whatever, problematic in a serious way, right? I can't go into, I mean, there's so many, and the pleadings are extremely detailed, okay? So we put these pleadings before the court. We had 21 days to get that stuff before a judge, right? 21 days over the Christmas holidays. And there was a lot of information, and we put them into all of these petitions. There was so much stuff, right, of clear breaches of electoral laws. And then we're served with a strikeout application. And we're thinking, well, this is a joke, right? This is a joke because these things are clear in law. It's not even something, if the revised list question where you don't use the revised list is not even something, if once you know the list wasn't used, it's either it was used or it wasn't used. If it's not used, there really isn't, there's no more to talk about. That's it. That's the end of it, right? Your only defense is it was used. That's it. And so we were not worried about what would happen on an application to strike out the petitions, because you don't strike out anything unless you can show that what you've put before the court is complete rubbish, right? I think the law is even, there's a word they use which is difficult for me to say because I have these braces that make it hard for me to speak. But it's the point is that it means that the tiniest pleadings, once it's recognized in law as a legitimate thing, you should be able to go forward, right? Now you've heard the things I've said that we pleaded, and many, many more. And then in their response, it's also you get struck out if the other side can say, look, they pleaded so much nonsense. I don't even know what I'm being asked to reply to, right? I don't know what this means, right? It's like me saying, I'm contesting these election results because I didn't drink coffee this morning. And you're like, well, what does it have to do with anything? We're pleading there's no revised list. There's importation of tens of thousands of voters or whatever. I forget the exact number, but it was a lot of voters, right? And they didn't say, we don't know what you're talking about. They said, we admit, right? And also, so what? So there's no question of, I don't know what you're talking about. It's like, yeah, we did it. And so it just shows the boldness of who they think they are and what they think Dominicans are, I felt, as a citizen of Dominica. And as an attorney, I was surprised. I was like, you don't admit things like that. Oh, this is easy, right? Like, what are we talking about here? And anyway, so the judge hears us, the Honorable Justice Glasgow heard us. And Justice Glasgow struck out every single allegation that we brought against that we brought in our petition. And not because he didn't think that we pleaded nonsense. It's because he thought, well, I don't think you can prove this stuff at a trial. So I don't think it's worth going to trial. I'm striking you out. And he basically went, so for example, on the DBS allegation, he said, okay, let's see. DBS is a state radio. DBS clearly did not, from what I'm seeing on the pleadings anyway, Clearly, they did not carry your stuff. You've said that. The other side have not denied it. Oh, by the way, their defense against DBS was that DBS is not a state radio. That was their defense. And the judge was like, no, 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 it's a state radio. That's fine. And he said, yep, so that's all right. That's right. But you've not told me that Roosevelt Skerrit, the Prime Minister, the Honorable Prime Minister Roosevelt Skerrit, or anybody working under him told DBS to behave this way. So therefore, I don't think you have good pleadings struck out. Do you understand how ridiculous that is? I don't think I have to explain why that is ridiculous, right? That's like saying somebody stole from me, but this other person didn't tell them to do it, so that's fine. Doesn't matter that you were violated. So that was really sad to hear, right? And then the on the revised list was okay. Yeah, the other side have not shown me that they use the revised list, and the law is clear that they're supposed to use the revised list. But I don't think you've told me anywhere that using the revised list affected the election result. So struck out. Well, we don't have to show you that. That's a call for evidence. Evidence is not required on pleadings, and in any event, not using the revised list is all you need to declare an election null and void, right? But that's what he said. That's what he said. And what was the other one I highlighted? The importation of voters. Right. No mention of the fact that they admitted it. What he said was that, what the honorable judge said was that, I think it was something along the lines of, we were not able to say who organized the importation of the voters. We didn't call any names, which we did, by the way. We did. And by the way, there was a lot of that. There was a lot of saying we didn't say things that we said. So, for example, one of the things that happened is that by law, we're required, the elections officers are required to let persons look at the list of newly registered voters so they can decide if they want to object to their names. That's a right by law to the public. And they hid the list. So people were being registered newly. These are the allegations, by the way. This is what my clients said happened. That's what we said in our petitions. That people who were newly registered and added to the list, to the voters list, the public was not allowed to look at the list to see who those people were. And we said, we pleaded the section that it came under. And then the honorable judge referred to a whole other section and says, that section doesn't say that, so struck out, right? It was really bad, really, really bad, guys. It was really, really bad, manifestly wrong. If anybody wants to look at the pleadings, I can make them available, right? And the response of the people on the other side. Now, importantly, there was no recognition that the respondents never said, we don't know what you're talking about. We don't know what the defense is. They defended it. Once you can defend something, then you've raised enough issues and things of fact to go on to trial. So a trial judge can hear all of the evidence and all of the witnesses and give a decision, right? And that's what we were prevented from doing. And the funny thing is, which is so infuriating, is that the rules, the House of Assembly election petitions rules, which guided us as to how we draft our petitions, it specifically says evidence is not required. So when the judge was saying, I don't have evidence of this and I don't have evidence of that, and it felt like such an ambush. Because in general pleadings, in any event, you don't plead evidence. You just plead facts that can amount to an elections offense or to some offense. You're not required to bring any evidence at all. The rules are clear. It actually says evidence will come at trial. So the point is, we wanted to go to trial. We wanted to bring our witnesses. We wanted to bring our evidence. And before any of that could happen, struck for no good reason. And it was so painful. It was so incredibly painful. I hope that's clear to people, right? And so we're thinking, all right, what do we do? So now this is what we have a problem. This is the issue. This is why everything is so dangerous, is because we have a constitution that says what just happened was an interlocutory matter, not final. And because
can you break down interlocutory?
Interlocutory means we didn't go to trial. Yeah. So the decision didn't come out of a trial. It was before you got to trial. Right? The trial stage, like I said, is when you bring your witnesses, like on TV, where you take the stand and people exchange witness statements, and somebody's to go into the story in a Bible and stuff, and then there's a decision at the end. So that's and sometimes it's a jury, sometimes it's just a judge, That's a trial. But what happened was a strikeout application where they said, hey, there's nothing here to see here. There's no reason to go to trial. We're going to strike this out right now. And when that happens, that's called an interlocutory decision. And so in the Constitution on election petitions, interlocutory matters, and actually quite a few regular court matters, interlocutory matters end there. In most court matters, in regular court matters, you can ask for leave. You can ask the court, listen, there are special circumstances where we can appeal an interlocutory decision. But in election petition matters, the Constitution says there's no room to even try to appeal. That's it. So we took a chance and we went to the Court of Appeal and we said, look, what we had before us is technically an interlocutory matter, but the judge made findings on evidence. He said there's no evidence of this, there's no evidence of that. That is just obviously wrong. And that's so unfair. That's just insane to keep this on the books because it's going to discourage other people. It's going to confuse the law. Like, when do you go to an elections petition? Nobody's going to want to challenge anything anymore if you cannot depend on the High Court judge to not do things like that. And then we found this case that the Court of Appeal had decided before, which suddenly left my brain. The Constitution, as to the constitutional, it will come back to me. If you know it, I know somebody is listening, you can text it to me, the name of the case. But it says that
Justice Andrea, can you help out there?
But let me describe it. Come to him.
Let her finish. I'll have my little comments on this,
Right.
framing of this as an interlocutory motion.
Yes.
Yeah.
Okay, cool.
So it's a case that came out of St. Vincent that said that Benjamin Exeter is a case. And it's one of the times where the Court of Appeal said there was the case was decided so badly, there was a kind of a bias in there. There was a clear bias. And even though it was an election petition, well, they didn't really go into the petition part of it, like the fact that they didn't go into the constitutional block that can happen. They just said, listen, your elections must be fair, and this is not fair. So therefore, we're going to allow this appeal. So we thought, oh, we can go. We can go too, because this is what happened to us. This is some kind of bias. So this is manifestly wrong. This is obviously wrong. Elections are important. And so it doesn't matter if it's interlocutory. Just like with Benjamin Exeter, you can hear us. And they said, no, we're not going to hear you. We're not going to bother with you. We're not going to consider this. We made a mistake, maybe. They didn't come out outright to say they made a mistake, but they said, Benjamin, well, we didn't really think about the question of whether the Constitution would have blocked us at the time. We were more thinking about the bias. So we were saying, well, which is it? So are you saying that bias doesn't matter in election petitions? So you would reverse Benjamin if you could? What is it? And we didn't get the answer. And they said, nope, this is an interlocutory matter. We can't hear you. Goodbye, right? So the next stage was, let's go to the CCJ, because now this is ridiculous. We just couldn't let this sit, because now the law is thrown in further disarray with the Benjamin Exeter thing. Because before that, I'm thinking, well, if it's a case of clear bias, when it's an election and fair elections are so important and the integrity of democracy, this is all the stuff they talked about in Benjamin Exeter. If the court was saying then that is a good reason to hear an appeal in a petition when the matter is interlocutory, surely that applies to us. And now we're being told no. And then we're begging them, look at the stuff that happened in Justice Glasgow's decision. You have to see that this is a problem. You have to see that we pleaded things that are important, that need to go to trial. And they said, nope, it's interlocutory. The Constitution speaks. We can't hear you. And so we thought the Caribbean Court of Justice, which frankly is where I thought we needed to go anyway, because of the magnitude of the matter and the magnitude of all the stuff that went wrong. We took a chance and we went to the CCJ, because we understood that the CCJ is about the public interest. And actually, that's the ground for leave to appeal to the CCJ, that you can have to show that this is something important to the public. The respondent said, no, I can't go. The Constitution. No, this is where we have a big, big barrier, because not only does the Constitution block appeals from interlocutory matters, it blocks any cases going to the CCJ at all. The idea is that petition matters end, no matter what, at the Court of Appeal. Okay. But there's another case that had come out of Guyana where the Court of Appeal was willing to hear election petition matters, but not to determine whether or not the elections were fair or not, just on other grounds, which, so we figured, well, the question of whether the decision was interlocutory or final, given how it was dealt with, right, how the matter was dealt with by Justice Glasgow, because we felt he made findings of evidence. So that was a final decision. And we felt that the constitution point had to be taken as well, because, we want fair elections. So we thought this is a good place to go. Hopefully they will hear us, right? So we said to the CCJ, so the respondent said, no, that you can't hear them at all. CCJ said, no, we're going to hear them, following that Guyana case and so on. They didn't give their reasons why, but that's what we were saying. And they said, yeah, no, we'll hear you. We'll hear you. And ultimately, they decided they didn't have the jurisdiction, which is what the respondents had said to them. So we were wondering, well, why did you hear us at all? If that's where you were going to go, right? Mm-hmm. But this is just me thinking as to why. It's either because they feel everybody should be heard when it's something important like an election, even if it's end up telling you no, or maybe they wanted to say what they said. And that's where my heart goes, is that they wanted to say what they said. They saw what went wrong and they wanted to say what they said. And I just would like an opportunity to say what they said and why we think this is important. Because the Apex Court the Apex Court have now said that our elections were tainted. And even if they don't have the jurisdiction because of the Constitution to hear us at all on all of the things that we say went wrong, they felt that from everything that they heard, ultimately, they saw a tainted election, and they went as far as to say they should never happen again in Dominica. All right. And I would leave it to some of your other guests to go into all the major detail, but I would just like to touch on or read the bits that are most important, that I felt were most important.
Mm-hmm. I think we'll let you take a break.
Okay.
While you get your information, collect your information.
Sure.
And then you can go to the side.
No. No, yeah, you could take a little, just to give her a little rest, you could play a song, let her continue, and then Justice Andrew will come in. This is the Workers' Voice. We have Miss James with us. I'm sure if you're listening, you already gotten a lot of stuff to chew on. So we're going to just let Miss James continue highlighting some of the major points of judgment by the CCJ. So we let her do that right away.
Okay, thank you. All right, so there are quite a few bits in the decision that give an idea of what the what the honorable judges of the CCJ felt about the elections, right, and about some of the things that were done. And I believe other people will speak about them, but I would like encourage persons to read at least paragraphs 97 and 77 of the decision to see how the judges really felt about what happened. The words like legitimacy of the government were used. Words like if people don't have fair elections, they're going to revolt and they're going to, this is very strong language that's being used in there. And one of the other guys can read those sections, but I just thought it was very interesting that they use such strong language, right? But in the end of the judgment, when it goes into final thoughts, it says, in conclusion, these appeals, meaning our appeal to them, these appeals have been dismissed on the basis of a want of jurisdiction because there was no final decision or order made by the judge for the purposes of Section 40 and 7 of the Dominica Constitution. So they're saying, well, we can't do anything. We have to dismiss it because the Constitution doesn't allow us to hear you. That's why we're doing it, right? But they say, however, there remain areas of grave concern about how the process of these elections was conducted. Future elections in Dominica ought not to proceed with these or similar taints. For my part, in relation to the electoral list, remember I talked about the revised list, and the related preliminary conclusions of the trial judge is Justice Glasgow, the first judge we would have appeared before, on the pleadings as to unlawfulness, the Court of Appeal arguably may have had jurisdiction on constitutional grounds, irrespective of whether the decision was considered in the context of Section 40 of the final or not. There can be no doubt that this particular decision conclusively preempted any further inquiry into arguably unlawful conduct by the election authorities that potentially went to the root of free and fair elections. Right?
Yeah.
So they are very clear that it is clear to them that there was clear unlawful conduct, or arguably clear unlawful conduct by the election authorities. What does that tell you about our elections and what they thought about our elections? And what I said in my message last night was that we did not ask or request of the Caribbean Court of Justice to comment on the elections, because number one, we were hoping to go back and have a trial, and we really wouldn't want to put them in a position that would prejudice a trial judge's mind. And also, it's just we understood that wasn't what. If they were going to take the position on the jurisdiction point, we didn't want to ask them to do something that they weren't required to do or by law. We were never asking them to make a decision on the lawfulness of our elections. We wanted them to take a decision that Justice Glasgow should have heard us, that there was enough before him for him to hear us. Not that what we said was true or false, but that it was enough to be heard at trial. And they said, from everything they heard, right, they concluded that there was unlawful conduct by elections authorities. I don't think there's any other way you can read that. And like I said earlier, there's other parts in the judgment where they use the word, questioning the legitimacy of the elections, right? This is really what I have to say. I think the importance of this judgment, though, well, here's the bad part, the bad news, and then there's the good news, right? The bad news is, in this decision, if we have another Justice Glasgow who sees perfectly well pleaded stuff that show that there is unlawfulness that happened in the elections, right? To the point that the CCJ will make this comment. And why they could make the comment, by the way, we have to remember that there was a lot of admissions, right? It was a lot of, we know we didn't use the revised list, no DBS, no challenge about the question on DBS. DBS is not state radio, which is not true. There was no real challenge to the pleadings. It was a lot of admissions. Yes, we imported people, big deal, right? So that's why they could make these comments. And that bit is not in the decision. But this is how I understand they could come to that conclusion. It's because of all the admissions, right? And how obvious some of the things are. So what it means, though, is that the next time there's an election and the judge does make whatever you call it an error. Maybe he wasn't paying as much attention. Maybe it was just too much stuff. I don't know why that happened, right? And I'm never going to impugn a judge's mind and say that the judge is biased. But I respect the judges. I work at the courts. These things can happen for whatever reason, right? But when it happens, you realize we have no recourse. That's what this decision says. But what it does say, where it helps us, and what is precious about it and why we cannot take it lightly. Number one, our CCJ is watching. And the next person that's brave enough to go there, they may say, we warned you that this shouldn't happen. And so it keeps happening. So something is going on. We have to take care of it, right? And it encourages us. It's saying, what it's saying is, do not ever go into an election without elections reform. Because that's what we need ultimately. That's what's going to stop this stuff. We need systems, proper systems in place where we can monitor and make sure that these things don't happen again. Okay. And that's what that decision gives us. And if it doesn't, prior to an election, if you see elections approaching and there's still no revised list and the DBS has behaved the way it behaved, you can go before an election, I'm thinking, all the way to the CCJ to say, we need to stop these elections because you told us never go to an election again without fixing these problems, and they've not been fixed. And the beauty of that is, why this is important is because we did try during the last elections to go to the courts. And we did go to the courts to say, stop the election. It's not because we knew this stuff already. We knew about the revised list. We knew about DBS. The day before the elections, we were in court with obviously the wonderful Cara Schillenfeld. I went with her and I said, look, I can help you with this, right? And we went to court on that. And the decision was, no, we can't hear you now. Deal with it on a petition. We cannot stop an election at this stage. Everything you raise belongs on a petition. That's what they said. And so we waited to do it on a petition, and look what happened. And it was the reason that was so tragic is because they're telling us there's no place else to go when that happens on a petition, right? When the judge doesn't take us on. So now we can say, no. We are not going on a petition because of what we faced the last time. And we now have this decision that says, we need to fix this. The CCJ have said, do not go into another election unless you fix this. That's how I'm reading this judgment. And that's what I'm taking in my heart for this, right? Not to be so sentimental, but as an attorney, I do get sentimental about my cases, right? So anyway, that's really what I have to say on that.
Yeah. Well, Justice Dr. Irvin Andre, we're happy that you're still with us. You want to come in now?
Sure, I'll come in. I'll come in anytime. Once I'm asked, I will come in. Let me say good evening to your panelists. Let me commend Ms. James for her eloquence and erudition, quite frankly. And let me commend those who took this matter, those who had the audacity to take this matter to the CCJ. In fact, this is perhaps the most important decision coming out of the CCJ with respect to elections and the propriety of steps taken during an election, particularly by a political directorate. Let me say also that one has to take some encouragement from the CCJ, because in the Guyana electoral case some time ago, they showed that they had the courage to rule against an incumbent. And that is significant because the rule of thumb in the Eastern Caribbean is that trial judges, high court judges, even Court of Appeal decisions, usually manifest a disinclination to rule against a party sitting in power. The CCJ has shown that it has no such compunctions. It will make a decision based on its assessment of the law and on the assessment of what is brought before the CCJ. And yes, as Zaida, is it Zaida? Yeah.
That's perfect. So some people say Zaida, some people say Zahida.
Oh,
Zaida. I don't care either way, but it's
wonderful.
Zaida.
But as she has clearly demonstrated,
Yeah.
Insofar as the battle is concerned, that is to say, whether in fact there was jurisdiction, there is a Pyrrhic victory for the other side. But in terms of the war for electoral integrity, in terms of the war for an equal footing in terms of how we conduct an elections, this is a momentous victory. Now, I am I need to say that because when there was a debate as to whether this matter should be taken to the CCJ, there were many dissenting voices. Dissenting voices which
Yes.
said that it's a waste of time, it's a waste of money. Dissenting voices which said that you guys are just sore losers. You guys cannot accept defeat. But the pronouncements of the CCJ is very fundamental and is very crucial. And it's a stinging rebuke of the political directorate insofar as how elections are conducted. You see, there's many, well, enablers in Dominica who, quite frankly, gloss over the egregious violations of the electoral law. And one thing is clear, virtually all the islands of the English-speaking Caribbean, they have basically the same type of residential requirements insofar as who can vote and who cannot vote. It is accepted that the media should be available to all contending parties. It is accepted that parties do not have the license to import voters to vote strategically. And it's kind of interesting, listen to Zaida, when she said, in fact, the trial judge, Glasgow, basically concluded that even if they imported voters, so what? What is egregious about this? What is so reprehensible about this is that the evidence. Now, I don't know what evidence was put before Glasgow in so far as the importation of voters, but there is evidence showing that voters were strategically placed into certain constituencies to vote with one purpose, to affect the outcome of that vote in a particular constituency. So for a jurist to say that, well, where is the evidence? Oh, so what? Well, I leave it to you as to what conclusions you should draw from this. But here's the CCJ on certain issues, some of which Zaida obviously did mention, although she is very much aware of it. The court says in paragraph 88, something to the effect, and I don't want to read the whole thing. The court said that the CCJ, I should say, what Glasgow concluded on the totality of the preliminary evidence was that in relation to the General Elections Act on December 6, 2019, there was a patent non-compliance with Section 17 of the Registrations Act. And here's what the CCJ has to say. This is a matter of the most serious concern that ought to be investigated, irrespective of the outcome of this appeal and of these petitions. The court was so indignant over the information presented to the court that they went out of the way. And as Zaida said, they had quite frankly, they had no right really, or they had no reason to go beyond addressing the only issue before the court, the question of jurisdiction. But they went way beyond that. And here's what they said in terms of the actions of the trial judge. Here's what they said in one of the paragraphs. Quote, striking out pleadings altogether could deprive a petitioner entirely of the right to a trial, which is the essence, the most important consideration here. And the court says further, a judge should therefore very sparingly adopt such a draconian measure. And it begs the question, why did Glasgow adopt such a draconian measure and dismiss the submissions of the petitioners in so short order? I don't know why, but I leave it to you to decide. Another important aspect of this SCCJ's decision is with respect to costs. In terms of the narrow argument, the narrow issue before the court, obviously the other side won. And typically the other side, the successful party, can claim costs with respect to its victory. The court, in my respectful view, took an unprecedented decision not to award costs. Why did they do that? Because by not awarding costs, they are basically saying that we or in their resolute refusal to award costs, they are basically saying that we will refuse to reward wrongdoing in general elections, whether in Dominica or elsewhere. We cannot award or we cannot reward those who, based on the evidence presented to the court, were engaged in wrongdoing. And that's what they meant when they said that the elections in effect was tainted. Now, I should indicate that the court basically said, here's how the court framed the case in paragraph 31. I'm going to quote the court because I want to make a comment on this. The court basically said the following, quote, in paragraph 31, was the decision of Glasgow J a final decision? He struck out all 10 petitions, as we know. It went on to say this, if they were final decisions determining that the candidates had been validly elected, then the Court of Appeal could not decline jurisdiction to hear the appeal. It says, if they were interlocutory, i.e., if they were not final decisions, then the Court of Appeal was bound to decline jurisdiction. But here's the problem. Here's the problem. The decision of Glasgow, upheld by the Court of Appeal, basically put an end to any adjudication of the substantial issues raised as to the fairness of the elections. It stopped it. It aborted it. So on one hand, the CCJ is saying it was not a final decision, but the reality is that the decision put a stop. It aborted it. It terminated the whole question with respect to whether this matter should go forward or whether the Court of Appeal should hear the substantive challenges posed by the petitioners with respect to the integrity of the elections. So the implication of the CCJ is that, look, as long as you frame these challenges as interlocutory, then there's no the appellate body has no right to hear it, and you are stuck. You have to perhaps say 1,000 novenas for something to change. So this is the effect of the CCJ's decision, to rely on a legalistic approach to this whole question without paying due regard, in my respectful view, to one, the interest of the public, and secondly, the integrity of the electoral process. Then quite frankly, you've put the whole question of electoral integrity, you've thrown it right back to the political directorate. And in effect, you've thrown it right back to those who question the integrity of elections in Dominica. And if there is an electorate, if there is a directorate that holds all the cards, whether in terms of money, whether in terms of the politicization of the police, whether in terms of the politicization of the Electoral Commission, then what recourse does the public have in terms of questioning the integrity of elections? That's the question. What recourse does the public have? So while, quite frankly, from many perspectives, what the CCJ did was perhaps the most important decision in terms of a rebuke of the political directorate, but it still leaves a great uncertainty as to the avenues that patriots or persons who are concerned with electoral wrongdoing, what avenues do they have if the political directorate controls all the cards? Perhaps that is where the diligence of the public would have to play a significant role, because otherwise, quite frankly, it will be deja vu all over again. But that said, we should take great solace in the fact that the CCJ at least recognizes how far short of the gold standard that we fall in terms of elections, certainly in Dominica. Because as I said, in no other island is there any type of tolerance for the importation of voters, for the bogus interpretation of electoral laws to suggest that there is some ambiguity in the legislation which permits the importation of these folk. In no other island do you have such a blatant and cynical manipulation of the state media to lock out the opposition from having any airtime based on the most capricious and silly arguments. And the question is, who will stop these practices? And I guess the sensitization of the public insofar as the significance of these practices may well have to determine the day in terms of whether we will continue to have this type of electoral process where the political legacy of one man will determine the outcome of elections, irrespective of any violation or violations of those self-same electoral laws. So this is a wake-up call. This is a call to order. This is a call to Dominicans to basically take charge of your electoral process and make the decisions and take the steps to ensure that you have an election which is one of integrity and which gives every political party a free opportunity to participate without any fear of victimization or vilification or persecution, or without any fear that the electoral laws will be interpreted in a fashion that favors one political entity. So that is my little 2 cents worth.
Thanks. Thanks, Justice Dr. Irvin Andre. Of course, we also joined my political leader, the Honorable Lennox Linton. Good evening, Honorable Leader.
Good evening, Honorable Daniel Luge. Good evening to Justice Andre.
Oh, thank you.
And
Appreciate
good evening to Council Zaida James, who has moved on to something else. She spent quite a bit of time with us this evening, outlining the case and underlining the importance of the certain aspects of the rulings of the CCJ. I want to begin tonight with a read of paragraph 77 of the judgment, which addresses the issue of free and fair elections. And it says, without free and fair elections, the value of the creation and maintenance of and respect for lawfully constituted authority would be fatally undermined. The consequence of such a denial that a reflection on Caribbean history demonstrates include loss of legitimacy, public unrest, and even revolt. In contemporary terms, free and fair elections are so fundamental to the democratic way of life that without it, the very legitimacy and sovereignty of the constitutional state is brought into question, constituted as is by the people of Dominica. In this regard, it is worth reminding ourselves the will of the people shall be the basis of the authority, legitimacy of government. The petitioners went to court with complaints against the conduct of the 2019 elections and complaints against the behavior of the Dominica Labour Party in these elections. The judgment tells us that the constitutional provisions reflect a particular policy to have election petitions fully determined as quickly as possible. Remember, the petitions are required to be filed within 21 days. The policy, the CCJ says, rests on the presumed competence of professional judges who are by no means infallible and who apply their discretion in ways that may not necessarily yield identical results across different judges. End of quote. So the competence level, the presumed competence of the judges is raised here. So yes, we have a policy. Yes, we have all these constitutional provisions and we have the law, but the matter of adjudication and just adjudication of matters rest on, at the court of first instance, rest on the presumed competence of the professional judges. The CCJ went I thought out of its way to tell us what was expected of the judge at first instance. And Justice Andrew referred to it a while ago, paragraph 27, where it says striking out pleadings altogether could deprive a petitioner entirely of the right to a trial. A judge should therefore very sparingly adopt such a draconian measure. Imposing tight timelines for the production of suitable particulars, coupled perhaps with an unless provision, is often a more just alternative. Further, at this interlocutory stage, the judge is not expected to conduct a mini trial on contested facts. We said over and over again that that is exactly what Justice Glasgow did. He had a mini trial on contested facts where he drew the litigants, the different sides, into the weeds of evidence where at the stage that they were, before you got to trial, the law provides that you don't get into the evidence, you plead the facts. Indeed, the paragraph 27 continues, the judge is in no position to decide at this stage the merits of a contested case, nor should the judge strike out pleadings if there are enough facts pleaded, if established, would show that the elections were sham, or that a different result would have been declared, and the respondents have a reasonable appreciation of the evidence with which they would be faced at trial. In weighing whether or not to strike out pleadings, a judge is often required to exercise some discretion, and the law ordinarily allows no appeal against the exercise of that discretion unless the prospective appellant is complaining that they have been denied or they apprehend a breach of a constitutional right, such as the right to a fair trial by an independent and impartial tribunal. Earlier, Justice Andre also referenced paragraph 88, which is very significant in the context of the presumed competence of the judge and how that impacted the trial. It says what Justice Glasgow concluded on the totality of the preliminary evidence placed before him on the pleadings was that in relation to the general elections held in Dominica on 6 December 2019, there was patent non-compliance with Section 17 of the Registration Act. This is a matter. Now, I told you what I'm saying here, what the CCJ said Glasgow did. They now go on to say, this is a matter of the most serious concern that ought to be investigated. And perhaps Justice Andre can tell us a little more what that means when the Apex Court is saying that this patent non-compliance with Section 17 of the Registration Act, which deals with the list, this is a matter of the most serious concern that ought to be investigated, irrespective of the outcome of this appeal and of these petitions. So notwithstanding what has happened here, the CCJ has ruled, and it has upheld the ruling of the appeal court. The CCJ is saying, notwithstanding that, this action of Glasgow ought to be investigated, irrespective of the appeal and of these petitions. So they go on to say at 89, the court agrees that for the purpose of these, Section 41A of the election petitions that challenge the validity of an election, the sufficiency of the material facts pleaded in these petitions was a matter for the first instance judge's discretionary assessment, with which the court will not likely interfere. However, that does not mitigate the egregiousness of the default, if true, taken in the context of free and fair elections and the democratically sacrosanct nature of the right to vote. Paragraph 100. What is noteworthy is the insistence on compliance with constitutional provisions and values and electoral laws that deal with the entitlement to vote. The right to be registered to vote is about the legitimacy of the voters list and is at the heart of free and fair elections. In principle, the integrity of the list is also what is really at stake. The view of this court is that non-compliance with electoral laws in this regard is an eventuality that the court must resolutely set its face against. Paragraph 101. While it is clear that not every or any procedural irregularity could result in an election being declared invalid, it is also clear that there may be some irregularities that could have that consequence. Such a breach would invalidate the election without also having to show that it affected the result. Lord Denning's first category, an election that was not substantially in accordance with the laws as to election, admits to this possibility. Indeed, in a constitutional democracy, an election that may not have met minimum constitutional thresholds could fail to meet the substantial compliance tests, understood and reimagined as including both quantitative as well as qualitative standards. In paragraph 102, the CCJ says, interference with these basic deep structure, principle, and value of free and fair elections, the core entitlement to vote, and the democratic sanctity of voting lists are arguably areas where quantitative impact on the outcome or result may not be necessary prerequisites for declaring an election invalid. And then, of interest in paragraph 105, the attention is drawn to these comments. The purpose and function of parliamentary elections include both process and outcome imperatives in the context of the constitutional democracy. Thus, while it is readily agreed that the objective of unequivocally determining the will of the people in their choice of a candidate for constituency is a fundamental purpose of parliamentary elections, it is accepted that it is either the only or primary purpose and function of elections. Equally, if not even more important than pure outcome, is the process by which elections are conducted, and in particular, that the process be seen and known by the citizenry to be free and fair and in conformity with the core constitutional values of equality, freedom, and fair participation, values that underpin the constitutional vision of democracy. In true representative democracies are built on at least one fundamental premise: the consent of the governed. The legitimacy of this consent is at least as dependent on the process of conducting elections as it is on the outcome. Thus, the constitutional premise on which to judge the purpose and function of parliamentary elections, and as a consequence, the purpose and function of representation petitions, as well as requirements for leave to present such petitions, is both outcome and process based. And finally, for me in this piece, the final thoughts of the judgment. Counsel Zyda James read them earlier. They're worth reading again. 108. In conclusion, these appeals have been dismissed on the basis of want of jurisdiction because there was no final decision or order made by the judge for the purposes of sections 40 subsection 6 and section 40 subsection 7 of the Dominica Constitution. However, there remain areas of grave concern about how the process of these elections was conducted. Future elections in Dominica ought not to proceed with these or similar taints. When something is tainted, it is poisoned, it is corrupted, it is adulterated, it is defiled, it is not fit for purpose. And with all those taints that the justices of the Caribbean Court of Justice were able to see in the election of 2019, from what was presented to them, they are advising Dominicans. They are cautioning Dominicans. They are admonishing Dominicans, people of Dominica, do not have elections in Dominica again if these taints are not removed. Paragraph 109. In relation to the electoral list issue and the related preliminary conclusions of the trial judge and the pleadings as to unlawfulness, the Court of Appeal arguably may have had jurisdiction on constitutional grounds, irrespective of whether the decision was considered in the context of sections 46 and subsection 47, final or not. There can be no doubt that this particular decision conclusively preempted any further inquiry into arguably unlawful conduct by the election authorities that potentially went to the root of free and fair elections. Operative terms here: preemption of further inquiry into unlawful conduct by election authorities that went to the root of free and fair elections in Dominica, which is what we came to the court about, which is what we have been about, which is what we've been advocating for, and which is what was our conclusion at the end of the 2019 elections. We issued a report. The report on that elections, which is dated the 30th of December 2019, is headed "Not Free, Not Fair, Not Free from Fair." And I find in this judgment of the CCJ a vindication of that particular report or review of the elections of 2019, especially in terms of the irregularities and the illegalities that tainted the process. And of course, vindication for the action of taking these petitions to court, of challenging the results through petitions. Because when we go to court, we don't decide, petitioners don't decide what sort of technicalities you're going to stumble against, jurisdictional or otherwise. You go to court with an honest need and request for justice. And we were seeking justice on the grounds that the elections in which we participated were not free, they were not fair, they were tainted with irregularities. The CCJ has told us that much. I wonder whether Justice Andre could address this.
Let me just chip in a little. My mic is off.
Yes.
Yeah. Justice Andre, before you continue, my sister is listening from Arizona.
Right.
I heard Justice Andre last few lines. She just joined us. Danny, I want to know from Dr. Andre what the people must do. Do they sign petitions? What exactly do the people must do to ensure that the list is cleaned up? So I'm just reading it.
Yes.
For my sister who is listening from Arizona.
Well, let me indicate that this judicial decision is the most damning indictment of Dominica's elections from a historical perspective. Never has a Caribbean court of law been so scathing in its clear conclusion that there should be no further elections conducted in the fashion of 1919. The court could have added of 2019, 2014, and so on. Again, as I said, the law speaks for itself. It is unequivocal, it is unambiguous. You have to meet certain criteria to be eligible to vote in Dominica. The whole business of importing voters and to strategically request that they vote in particular constituencies to neutralize the threat from the opposition, the electoral threat, is just fundamentally wrong. The court is aware of that. The court knows, and the court basically is expressing grave concern about judicial myopia, judicial blindness, willful blindness by judges who pretend that they don't know what's happening. And that's exactly what one can conclude when one reads the CCJ's decision insofar as the trial judge's decision is concerned. What do people do? Again, I cannot instruct persons what to do, but I can express my private, personal opinion as someone who traces his roots to Dominica over 150 years, that the time for petitions are over. Dominicans have to take encouragement and example from their fellow Caribbean nationals, whether in St. Kitts, whether in Antigua, whether in Grenada, that enough is enough. Dominicans do not have the luxury of waiting on the Caribbean leaders to sound the alarm that something is wrong in terms of elections in Dominica. These folks have turned the other cheek. These folks have manifested an unprecedented degree of blindness towards what's happening. They will not tolerate these excesses in their respective islands, but they have no problems looking at Dominica, smiling, while the democratic rights or while the Constitution of Dominica is being eviscerated, is being desecrated. Why? On the altar of maintaining power at any cost. So in my respectful view, Dominicans have to stand up for the Constitution. They have to stand up for the integrity of the electoral process. They have to stand up for the rule of law. That's the important thing. And how much evidence do you need to know that those who maintain the levers of power do not recognize petitions? No, they do not recognize petitions from the truckers or from the state college teachers or from anybody else. So this is the thing. Dominicans have to stand up and be counted. You have a right to be here, no less than the moon or the stars. And whether or not you are made to feel like a second-class citizen in your own country, at some time you have to get up like Rip Van Winkle, who slept for 30 years, and say, it is time to assert my integrity, my patriotism, and my desire to maintain what is right in my own country. That's the bottom line. Dominicans have to maintain the integrity of those laws, the Constitution that govern them, that protect them, and they have to say, quite frankly, 10 pieces of silver is not enough to cause me to surrender my integrity. It's as simple as that.
Thanks, Dr. Andrew. I do appreciate it. What we are going to do now is just take a break and shift a little bit and allow callers. I know there's many people out there itching to make some calls. I noticed a while ago that the system was lighting up. So we'll give out the numbers and taking some calls and move on. The time in the studio is 4 minutes after 10. So how quickly time flies. How quickly time flies. The numbers are 449-3095, 449-3096, 449-3097, 616-4257, 305-432-9624. We're taking your calls right now. 449-3095, 9697, 616-4257, 305-432-9624. And there is someone already on the line. Let's take this call.
Hello, good evening.
Good evening.
I was a bit disappointed by the judgment for a number of reasons. Like when I heard that the case was going to be held by the CCJ, I actually wrote a brief on the matter. And I won't go into every reason why I'm disappointed, but I want to point out something. We have the law and the Constitution. Section 47 is the reason for the court's judgment. But there's a principle that says that different parts of the law cannot be interpreted in opposition of each other. And what I didn't hear from the hearing is Section 66 of the House of Assembly Elections Act, which says clearly, every election petition shall be tried in the same way that you try cases that come before the court otherwise. Obviously, these cases don't come in the same way, these petitions, because you are given 21 days to file your case, and there are statute of limitations for other cases which are longer than 21 days. The important thing is that the Act says that every election petition shall be tried. It makes no provision for strikeout petitions because they must be tried. It didn't say may be tried, it says they shall be tried. So when the Constitution says that no right of appeal holds unless it's a final decision, it is clear that it is not referring to a strikeout decision because the Act clearly says that every election petition shall be tried. And I think that's why I'm very disappointed. It's obvious from listening to what was said by everyone here and from the citing from the court's judgment that the court wanted to find for the appellants, but they somehow missed Section 66 of the Act. Because, take for example, the fact that the court heard the appeal was striking to me, because what they should have done if you followed strict procedure was when they found that the court below was wrong not to hear it, was to send it back and ask them to hear the appeal. They said, no, we aren't even going to send it back to you. We're going to hear it ourselves, which shows that they wanted to hear. And that's why I thought that when the question was asked in the hearing, what do you want us to do? That a trick was missed and probably has to do because of the way lawyers interpret the law and have not seen Section 66 as being relevant. But I just want to bring that out, that the Act is very clear, that every election petition shall be tried. There's no room in this Act for strikeout petitions. Yeah, thank you.
Thank you.
I thank the contributor for his observation. I'm not familiar with the submissions made to the CCJ, but certainly the caller makes a very interesting point. Something I personally am going to follow up because I'm not very aware of that provision in the General Assembly's Act. But I cannot respond because I don't know whether, in fact, that was a submission made by counsel for the appellants to the CCJ, insofar as the mandate that every petition should be tried. I mean, that would be an interesting point to make. And it would certainly have been very interesting to hear what the CCJ's response is, quite frankly. Yeah. But again, as well-meaning and as well-intentioned in my view as the CCJ was, it basically does keep the door closed to a significant degree in terms of the challenging of the conduct or the manner in which an election is conducted. Because bear in mind one thing, if hypothetically you have a trial judge who's sympathetic to the directorate, if hypothetically you have a trial judge who adheres to the overarching view if it is true that judges are indeed reluctant to make decisions which offend the political directorate, then quite frankly, we're in some deep trouble. We are in some deep trouble because the Court of Appeal has says, that's all. I have no jurisdiction. The CCJ have upheld that decision. So can you imagine the chaos that would ensue? You know, if it is the case, and I don't know, if it is the case that a central criterion for judicial decision making is a scrupulous desire not to offend the folks in power, that is a very sad state of affairs. But
I think we have a caller on the line. Let's take a call. Good evening, caller.
Hello. Good evening.
Yes, go right ahead.
Yes, I have one little problem with that election and electoral reform. I am saying that if these guys do not have electoral reform, I'm telling their position, they should still contest the election. Otherwise, Adolf Hitler, better known as Kerry, will just be in power again. You refuse to contest the election, he's going to call the election, then these guys will be in power. It is very sad, but you cannot allow this guy to do that. And that is what he and Tony Astafan are up to. That guy, Tony Astafan, I don't know, man, he's a criminal. I don't know how you people can tolerate him. Unbelievable how, I mean, domination sucks. Thank you.
Yes, okay, Mr. Linton.
No, I wanted to go back to paragraph 88 of the judgment and to ask Justice Andre, what does he think is being suggested here? Because it says what Justice Glasgow concluded in the totality of the preliminary evidence placed before him on the pleadings was that in relation to the general election held in Dominica on the 6th of December 2019, there was a patent non-compliance with Section 17 of the Registration Act. This is a matter of most serious concern that ought to be investigated irrespective of the outcome of this appeal and of these petitions. What does investigation in these circumstances mean? Because we have the judgment, we have the petitions are over, but he's saying notwithstanding that, there needs to be an investigation.
It is an interesting question, and the way I personally read it is that what has to be investigated is, quote unquote, the patent non-compliance with Section 7 of the Registration Act. But let me throw out the $64,000 question. Who is going to conduct that investigation if all the institutions of governance are controlled by the directorate? You tell me. Jesus Christ doesn't investigate anything the last time I checked. Who is going to do that investigation? The regional force that tear gassed the village on the eve of an election? Are they going to do the investigation? Mia Motley from Barbados? Who is going to do the investigation?
Who? Yeah.
Callers, the line is open. We welcome in your call. Good evening, caller.
Yes, I'm back because Mr. Linton reminded me of a point I wanted to make. We speak about the organs of government being whatever. Let us remember that the court is a part of the government of Dominica. And in that capacity, they have the authority to investigate it themselves. Because this is not, we have a three-part government, the legislature, the executive, and the judiciary. And if the judiciary is convinced that something is wrong and something is to be investigated, considering especially that the judge in question is an officer of the court, the court has the authority under the Constitution to conduct the investigation that it says is required. Thank you.
But again,
Thank you very much, caller.
Again, it does have the authority, but again, we cannot assess that authority in any abstract fashion. The question is, who is going to conduct that investigation? Who is going to summon, who is going to institute an investigation in terms of questionable judicial conduct? If, in fact, there is. That is the problem. Based on the history that we've had to contend with, there are rules and regulations and policies with respect to how long a judge might remain in a particular island. Who is going to investigate any violation of that policy or that rule? You tell me. When Sir Brian, and I understand that he is going to be honored by Q95, and I congratulate him.
Kudos to our heroes.
Who investigated when a prime minister of one of the islands blatantly and egregiously refused to confirm his appointment as Chief Justice because Sir Brian had the audacity to rely on his integrity to make decisions which ran contrary to the political directorate? Where was the investigation, Gasol? There's no investigation. We know that. We know it's bad movie, that goes on in certain circles, let's put it that way. So that is the reality that we face. And that is why, quite frankly and unfortunately, the judicial system has attracted so much censure. There are good people who are judges. I know a few of them. There's one in Dominica, I know her well. She's a great judge, person of integrity. And there are many other judges who are persons of integrity. But the judiciary is no different. It is a microcosm of society. The judicial decision has its bad apples, just as every other institution has its bad apples. But the question is there a will to ensure that those bad apples do not pervert the course of justice?
Let's take another call.
I will let you answer that.
Good evening, caller.
Yes, good evening, gentlemen. Very interesting program. That's my thinking. Reviewing what was the decision that was made. Shouldn't the attorney who represented the United Workers' Party ask the judge to institute a court order that this thing will not take, so they will have their document for their paper trail? I'm just asking. Thank you.
Thanks, caller. Let's take another call. Good evening, caller.
Good evening. Good evening. I'm listening to an interesting discussion. I can preempt and say something that all institution of moral authority has been politically compromised. But can they write an application to the CCJ to ask a panel or some subsections of the CCJ to investigate what needs to be investigated? Good evening. I'm listening.
Thanks, caller. Good evening, caller.
Sorry.
Yeah, let's just take that one other call. Yes, go right ahead.
Yeah, good evening to Mr. Linton.
Good evening, sir.
And good evening to the judge. I forgot his name.
Dr. Andre.
Okay, well, good evening to the entire panel.
Yes, good
everybody.
evening.
Now, Mr. Linton, I'm sitting on my bed and I decided I'm going to call you to ask your question. But I find it unfair. The question I was going to ask you how confident are you, based on the CCJ advice, that is going to happen in Dominica? But I said, no, I cannot be asking you that question again. I have been asking too many questions and you have been always answering. I'm not going to change the whole thing, and I'm going to ask my Prime Minister this question tonight. Mr. Roosevelt Skerrit, I am a citizen of the Commonwealth of Dominica. I am going to begin asking this question tonight. Will you follow the advice of the CCJ? Will we have a next election in Dominica with a proper electoral reform? Good night.
Thank you very much, caller. Good, Dr. Andre, go ahead.
I forgot what was the first question I was going to respond to. But again, it is clear that the whole question of investigating, the whole question of ensuring the integrity of the electoral process cannot be entrusted to any one institution in Dominica. If past is prologue, that is the only message we can glean. The only, in terms of the CCJ instituting an investigation. I don't believe that they have that authority, to be honest with you. I think the judgment is a clarion call to the citizens of Dominica, that they have a role to play in ensuring the integrity of the electoral process. I think that is what it amounts to. As to the prosecution services of the island taking anything, the last time I checked, didn't they nully pros the last CCJ decision?
Well, what
With
happened?
respect?
Yeah, well, what
Isn't
happened?
what they did? Short
Well, the
circuit the whole
CCJ
process?
ruled. The CCJ ruled and said that the matter was properly before the court, and a trial date should be set. That matter was the criminal complaint for treating that was lodged against 15 members of the Dominica Labour Party that contested the 2014 elections, and it had been in the court system for some time. When it finally got to the CCJ, where they were claiming it did not belong in the court and so on, the CCJ said, no, this matter is properly before the court, set a date for trial. And the date for trial was set, and while they were waiting to go to trial, up comes the DPP and quashes the case, saying that there was no chance of it succeeding. So,
I think yes. Go ahead, Mr. Linton.
To answer the caller's question, which he asked me, but then did not ask me, as to how confident I am with that what the CCJ is advising. We're going to heed the advice of the CCJ. I'm not saying that we should, because now this matter of free and fair elections and the need for electoral reform is no longer something that you can say, oh, it's opposition people talking about it because they contest elections and they don't succeed, etc., etc. The independent arbiters in our system of justice at the highest level, the apex court of the Caribbean Court of Justice, has said to the people of Dominica in very clear terms, nothing ambiguous about the terms, do not have another election in Dominica before you remove these taints to the process that have impacted free and fair elections in the country. Don't do it. So in other words, and I was wondering, why did justices of the court of the Caribbean Court of Appeal, no, the justices of the CCJ, went back into the petitions to do a summary of all of the claims made by the petitioners and how the judge treated them in the strikeout application. And to say that they were not commenting on whether the judge was wrong or right, but they wanted to list out the complaints so that when they come back to talk now about the electoral process and the taints, we who have read the judgment would have a clear idea of what they're talking about. And there are a number of things to be dealt with. There are a number of things to be dealt with in terms of the illegalities and irregularities that have tainted, have poisoned, have corrupted, have adulterated, have defiled the process of election in Dominica and rendered it unfit for the purpose of electing government of the people, by the people, for the people, as the backbone of our democracy.
Dr. Andre, we want to give you the opportunity. Let's just take that last call and then we'll ask Dr. Andre to wind up so that he could go meet his wife.
Hello, good evening.
Good evening, caller.
Yes, I'm trying to be as practical as possible. The decision clearly spoke about what is the cornerstone of our democracy, which is a free and fair election. And they emphasized repeatedly the importance of having a revised voters list. I am quite aware of a gentleman who sought to follow the letter of the law in terms of objection for someone who have registered contrary to what the law requires. I'm speaking specifically to the residency requirement. It says you have to be resident in a particular address for 90 days or let's say 3 months. And there are people who came down for Carnival, got registered on River Street, and were objected to, where the gentleman went through the procedure of getting the objection form as prescribed by the law, put down a number of names in his polling district according to law. He then got a witness to witness his objection according to law. It was then submitted to the electoral office according to law. Lo and behold, those names appeared on the final list for election. So what it is that we're going to tell people who want to follow the law and assist the electoral office in ensuring that the list they have is one that can stand up to scrutiny. And yet, when you follow the letter of the law, particularly in rows where it is easy to identify houses, addresses, if it is a vacant lot, if it's an abandoned lot, if it is a business place where you know you cannot register on all of that. How is it that a business place on Old Street which sells fast material could have a name registered? How it is in the corner of Old Street and River Street, somebody could be given money to open a bar, come there for a few days to show that there's a business, and then register names on that business. How could it be on Kings Lane, a lady from the village of Granby can open a store, register residency on that store address, when every time at 4 o'clock, and sometimes because sales so slow, by 2 o'clock that store is closed, and you will not see a light in that property in the night. Yet still somebody could register on that. And the objections to these violations of these laws was not given the opportunity to be ventilated in a court. What alternative do people who want to follow the Elections Act have when they are turned down at every corner? This is the question I would like answered.
Thank you, caller. Yeah, Dr. Andre?
Well, enforcement of the law is the people's business. It is not just a law enforcement. It is not just the function of the police. In fact, if it is true that there were police officers who were escorting persons who were coming through the back door to come to participate in Dominica's elections, then quite clearly we would be fundamentally naive to believe, if we need any other evidence, and we should not, that quite frankly, the whole question of law enforcement is in many respects tainted, just as the CCJ described our electoral process. The question is, how much value do we place on the integrity of the system of voting, or the integrity in the system of good governance? How much value do we place on it? A bag with a corned beef, sardine, 2 loaves of bread, not even an Afua with big mastiff. Is that the value we place on the significance of our election? What are we prepared to sacrifice? Huh? What are we prepared to give up? Huh? The violation of a child? Give up a spouse? Get a little house so that we can turn the other cheek, and we can vilify and persecute and victimize those who stand up for the integrity of the system? What example do we take from Grenada? What example do we take from hopefully St. Kitts? What example do we take from some of the other islands? In terms of the war, not war in terms of in the classical sense, but the struggle they have waged to ensure that they have a free and fair election, because it is so important to good governance. It removes all the cynicism. It removes all the tainting of corruption. It removes all the sense of unfairness or victimization. It sends the message to those in the diaspora that you can come home and be relaxed and build and invest in your country because it's worth preserving. It is not a bowl of stew that we are giving away. There is much more value to it than a few dollars more. So that is the fundamental question to the caller. Ultimately, what value do we place on the preservation of the integrity of the island of Dominica? To what extent are we prepared to stand up and say we must be counted? And life is strange, isn't it? It is disproportionately, not always, but in too many instances, it is those who show that they are prepared even to walk on Wednesdays. It is those who we would dismiss in another generation as j'habitation, who are showing a little courage. While it is those so-called privileged ones, not all of them, because many of them have supported the cause of good governance, but who are most cynical, most capricious, most self-soothing, and who are the biggest enablers to what's happening in this fair isle. And that is the cruel irony of all this, you know. It is those who have the most to lose who disproportionately are taking a stand and risk the process of being victimized. And we have to take courage from that, because sometimes in the darkest hour we believe that all is lost. But sometimes there's a vision of David with a little catapult, or with his moral rectitude, standing up and saying, enough is enough. And that is what that will rescue Dominica from this abyss of despair, from this precipice, from this chasm of corruption, from this cynicism. That ultimately is what will rescue Dominica, what we are prepared to do to rescue or restore our institutions that have all metastasized and have manifested the disease that is slowly taking over the body of my Dominique. There is hope.
Thank you.
A caller earlier raised the matter of objections, complaints, and the legal responsibility for dealing with those objections and complaints in compiling the list of voters. So we had argued, the petitioner had argued before the court about objection complaints, that they were not dealt with as the law required them to be dealt with. There was also a complaint, a significant one, about Section 17 and of the Registration of Electors Act, and the use of the list that ended up in the election. The list that ended up in the election was not the correct list. And in another case in St. Kitts and Nevis, it was ruled that where you did not use the proper list for the election, the one that the law requires to be used, then you are not in compliance with the law, and the election can be set aside as a result of that. That matter was raised. In the case of the objection complaints, the court ruled that these pleadings did not indicate how the alleged failure to resolve the objections tangibly affected the results of the election. And then in the case of the list, the ruling was the judge said there was not enough pleaded to indicate how these alleged breaches of the electoral laws affected the outcome of the elections or rendered the elections a sham.
Is that Justice Drago?
No, that is Justice
Glasgow.
And that is why the justices of the CCJ made such a big deal in the judgment about the electoral list issue and those related conclusions at preliminary stage of the trial judge relating to unlawfulness, because he said that there was patent non-compliance with the requirements of law at Section 17 of the Registration of Electors Act. In another jurisdiction, that patent non-compliance with the requirements of law, insofar as the lists are concerned, would be enough to set aside the election. So that when in the judgment of the CCJ, they reference the conclusive, the decision of Glasgow conclusively preempting inquiry into unlawful conduct by election authorities that went to the root of free and fair elections. This is massive. It is significant because elections, free and fair elections, can only be the result of compliance, strict compliance in the process, electoral process, with the rule of law. With the rule of law, the constitutional rule of law. The justices of the CCJ tell us that didn't happen in this case. And so there's a message here as well for the Electoral Commission and how it functions. There's a message for electoral authorities in Dominica, because regardless of whether we have the best legislation and we provide as properly as we can for what is supposed to happen in an election, in legislation, at the end of the day, the people who are responsible for the conduct of the election have to come to the table with integrity, with honesty, and commitment to the cause of free and fair elections as the backbone of our democracy. Because we've seen a lot in this case where it is not just that the members of the Labour Party misbehaved and broke the election laws in terms of the overseas vote and in terms of certain other kinds of manipulation of the process, abuse of incumbency, bribery, cheating, etc. It's also that those responsible for the conduct of elections had certain responsibilities that, for whatever reasons best known to themselves, they did not carry out according to the provisions of law. And that is why, when all of this is taken together, the Caribbean Court of Justice is saying to the people of Dominica, please, we are begging you, we are warning you, we are beseeching you, we are admonishing you. Do not have another election in Dominica without the electoral reforms that will remove these taints, these corrupting influences, these poisons, these examples of defilement that make your election process not fit for the purpose of electing government of the people, by the people, for the people as the backbone of your democracy. Do not do it. Get yourself to right order. And somewhere in the back of my head, I'm hearing the name Sir Dennis Byron, because 3 years ago, Sir Dennis Byron was given an assignment to look into all of the recommendations that had been made to us on electoral reform, to conduct his own consultations with stakeholders across Dominica, and to provide in recommendation some sort of roadmap going forward for electoral reform. And when we met with Sir Byron back in September of 2021, middle of September, we were told that within 8 weeks, 8 to 10 weeks, the report will be out. 8 to 10 weeks would have taken us to November sometime, I would think, in middle of September, October, November. And so let's say middle of November, end of November. December, January, February, March, April, May, June, this is July, 8 months, nothing further. But we have now the decision of the CCJ that tells us about how we should go forward. And we only hope, while the Electoral Commission is sitting with its hands between its legs, waiting to hear on Sir Dennis Byron, that this whole process will be expedited, and we do not come to a situation where anybody is going to suggest to us that another election is going to be held in Dominica without electoral reform.
Well, let me say thank you to Justice Dr. Irvin Andre for staying up more than 2 hours. He was there very, very early. We really appreciate you, sir, for enlightening the Dominican public. We want to say thanks to Zaida James, counsel. She was with us for about 1 hour. We want to thank Lambi. We want to thank all the callers. It's a sacrifice of love to be in studio 2 hours in a row every week, week after week, but we believe it's very important. So I just want to say good night from my end and God bless.
Good night to you. Good night to your listeners. Good night to Lambian
Thank you very much. Always a pleasure.
Good night, Mr. Linton.
All the best.
All right, Mr. Lugay. Thank you.
Good night.
Thank you. Thank you very much. Thank you, Dominica. Love you all the time.